Hello and welcome to Narayana IS. I'm Pratik, your faculty for Polity, IR and Security. Students, we know that yesterday we started with a new theme, the new theme being the constitutional, the statutory and the executive bodies. We discussed a few topics under the new theme and today we'll try to complete all the topics under the theme, right? So let us start with the 23rd Law Commission, right? Now, what is the context? The Government of India has constituted the 23rd Law Commission following the approval from the President. This is the context. Now, let us try to understand the Law Commission, whether it's a statutory body, executive body, or let's say a constitutional body. Now, the Law Commission of India is a non-statutory body. It's a non-statutory body, or rather it's an advisory body established by the Government of India. Who establishes it? Not the Government of State, but it is the Government of India that establishes this non-statutory body referred to as the Law Commission. The purpose is to advise the Government of India. And the Law Commission, it forms or it falls under the Ministry of Law and Justice. It falls under the Ministry of Law and Justice. So please remember that the Law Commission was first set up in the year 1955 after a few years of our independence. And since 1955, it has been reconstituted periodically. Why? What is the purpose? To carry out research and also suggest reforms to improve India's legal framework. For example, we know that the new criminal laws have replaced the old ones. So who suggested? It is the Law Commission. So it is a Law Commission who carries out the research and then also recommends the Government of India with respect to making changes in India's legal framework. And if I talk about the purpose of Law Commission, the commission's main purpose, what is the main agenda, main objective is to review and also to revise all the existing laws. Why? Purpose? To ensure they remain relevant and effective. Which means the law should, align with the modern realities. And if the law is not aligned with the modern realities, the laws become irrelevant. And that's the reason the purpose of the Law Commission is to review and revise and then ensure or recommend the new laws whenever they are necessary. Like it recommended that, the Bharatiya Nyaya Sanhita, BNSS, or so the three new laws replace the old laws. Who recommends it? The Law Commission. The composition, now this is often asked in the examination, the composition is composed of the legal experts. Legal experts including the judges, lawyers and academicians, and is headed by the chairperson, and chairperson is often a retired judge of the Supreme Court. So this is the composition. So again, you should know that it's neither a constitutional body nor a statutory body, it's a executive body. Non-statutory, what does it mean? Who constitutes it? It's the Government of India. It's the Government of India who constitutes it. Not through law, neither is a constitutional mandate, which means it's an executive body. So I hope these key points are important for the examination, right? You're clear with the key points. Now, the functions and role of the Law Commission. As we discussed the purpose, so the Law Commission is tasked with reviewing the outdated laws. Then it also recommends the legal reforms, and it also identifies those laws which are totally meaningless, totally irrelevant. And then it also provides recommendations on the legal matters. And these legal matters are then referred by the government, or they are taken up on its own initiative. Finally, once it reviews, it revises, it sort of recommends, the commission then submits a detailed report on various legal subjects, and then these detailed report can be used for drafting new laws or let's say amending the existing laws. So it is based on the recommendation of the law commission. So the report of the law commission helps the ministries, departments to make a law. Now talking about the tenure and nature of work of the law commission, now each law commission has a term of 3 years. So please remember this point. This is important for the examination, and then after 3 years a new commission may be appointed. Now please remember the recommendations of the law commission. The recommendations of the law commission, they are advisory and they are not binding. It's advisory and not binding on the government of India. So this is something that you need to remember. Now the terms of reference, we know the 23rd Law Commission has been appointed. So which are the terms of reference that have been submitted to the Law Commission? One, the Law Commission has been directed to identify the laws that are no longer relevant. This is what every Law Commission is given the task. And then it also is asked to recommend new laws to replace the old ones. Then it has been asked to suggest new laws to implement the directive principles of state policy and also achieve the objectives as mentioned in the Constitution's preamble. For example, justice, liberty, equality. So how the directive principles of state policy can be translated into law is something that the Law Commission will suggest. Then the commission, they will provide its own its views on any legal or let's say judicial matter that is referred to by the government, which means the Ministry of Law and Justice refers to the Law Commission and it requests the Law Commission to give their views on any legal or let's say judicial matter. For example, the appointments of the Supreme Court and the High Court judges. It can be asked. Then it may also be requested to also assist the foreign countries with legal research. So here they are also tasked to help the foreign countries whenever the government of India asks them to. And then from time to time, the commission will prepare and submit the reports to the central government. Right? And we know that it also provides recommendations, and again the recommendations given by the Law Commission to the government of India, they are advisory, they are not binding. So these are the points that you need to remember. So these are the key points that you need to know about the Law Commission which can be asked in the examination. So make sure you remember all these points. So I'm focusing only on those points that can be asked in the examination. High chances of being asked in the examination, right? As our program is prelim specific, so I'm just focusing on those points. The UPSC may ask a question in the prelims examination, so make sure you're revising the topics that we are discussing. Any question, any doubt, again you're free to ask in the comment section. Okay. Okay. Let us move on to the next topic. The next topic talks about Lokpal. Now the context is the former Supreme Court judge, right? Again, name is not important, was recently sworn in as the Lokpal chairperson. So in this topic, we'll understand about the institution of Lokpal. What is Lokpal? Now please remember that the Lokpal is an anti-corruption authority. The purpose of Lokpal is to fight against the corruption. This Lokpal was established under the Lokpal and Lok Ayukta Act of 2013. Lokpal and of 2013. It was established under this law. The law provides for the formation of Lokpal. So Lokpal is at the national level. It's at the national level, and Lok Ayukta is at the state level. So every state would have one Lok Ayukta, and at national level will have one Lokpal. So Lokpal or the Lok Ayuktas will act as ombudsman. Ombudsman. Meaning, what is the purpose of, or what is the meaning of ombudsman? Which means the Lokpal and Lok Ayuktas, they are given power, they are empowered to investigate complaints of corruption against the public officials. The key word is investigating complaints against public. This is the keyword. Public officials, not the private officials. So, what is the purpose? The purpose of Lokpal is to fight corruption cases both at the national as well as at the state level. For national level, we have the Lokpal. For the state, we have the Lok Ayuktas. Now, if I discuss about the historical background and the genesis of Lokpal, the origin, now 1809, before independence, the concept of ombudsman was first introduced in Sweden. Right? So, the concept we are taking from Sweden. In 1960s post-independence, the idea was proposed by the law minister, and the terms Lokpal and Lok Ayukta were coined by L.M. Singhvi. This is post-independence. In 1966, the Administrative Reforms Commission recommended the establishment of the Lokpal, and finally in 13, following the Anna Hazare movement in the year 13, finally the Lokpal and Lok Ayukta Act was enacted. Right? So this is something that you need to remember. The concept was first introduced in Sweden. Right? Now, if I talk about the key provisions of the Lokpal and Lok Ayukta Act, now the selection committee is responsible for appointing the members of Lokpal. Selection committee. Now, this is very, very important for your prelims examination. Why? Because the committee, which committee? The selection committee consists of one, the Prime Minister, second, the Speaker, third, the Leader of Opposition, fourth, the Chief Justice of India or a judge nominated, and fifth, one eminent jurist. So there are 5 members who are a part of the selection panel. The Prime Minister, the Speaker, Leader of Opposition, then we have the Chief Justice and an eminent jurist. These are the 5 members who are part of the selection panel. Very, very important point for your prelims examination. Now, key provision, the structure, which means Lokpal is Lokpal. It includes one chairman and up to 8 members. So 1 plus 8 members. 1 is the chairperson. The chairperson can be a former Chief Justice of India or former Supreme Court judge or an eminent person with at least 25 years of experience in fields such as anti-corruption, public administration, vigilance, finance, law, insurance, banking or management. So this is the condition eligibility for the chairperson. What about the 8 members? Of the total members, that is 8 members, 4 out of 8, 4 members must be judicial members. And at least remaining half must belong to categories such as SC, ST, OBCs, minorities or women. So 1 plus 8, 1 chairperson, CJI or former Supreme Court judge. Of the 8, 50% should belong to the judicial category, 50% should belong to these categories. A judicial member must either be a former Supreme Court judge or a former Chief Justice of a High Court. Chief Justice of a High Court. The tenure of the Lokpal chairperson and members is 5 years or until they reach the age of 70. So 5 or 70, whichever comes first. Again, each and every point very, very important for the examination. So make sure you remember each and every point pertaining to the institution Lokpal. As I told you, they investigate into complaints against the public officials. So jurisdiction powers can investigate allegations of corruption against the Prime Minister, Union Ministers, Members of Parliament, government employees belonging to Group A, B, C and D. It has the authority to examine the foreign donations exceeding 10 lakh under the FCRA. Now again a statement can be asked. Lokpal, they have the power to also investigate into complaint under the FCRA. FCRA is something that we discussed already yesterday. Please revise the points under FCRA. So yes, it has the power authority to also examine the foreign donations under the Foreign Contribution Regulation Act. Then it has the supervisory powers over any investigating agency, including the CBI. So this is the power, or let's say jurisdiction of the Lokpal. So these are the important points that can be asked in the examination. Make sure you're revising each and every point. Let us move on to the next topic. The next topic talks about the National Commission for the Backward Classes. Now, what is the context? The National Commission for Backward Classes, right, recently considered 365 castes and communities for inclusion in the central list of the OBC 365 between March 14 and November 2024, according to the Union Ministry of Social Justice and Empowerment. So, this commission is very, very important. Let us understand about this commission. Now, National Commission for Backward Classes. Please remember that National Commission of Backward Classes is a constitutional body. So again, you need to know the institution, whether it's a constitutional body, whether it's a statutory body, or whether it's an executive body. So National Commission for Backward Classes, this one is a constitutional body, which means it is established by the Constitution of India through the 102nd Constitutional Amendment Act 2018, which is before 18 it was not a constitutional body, and this NCBC was made a part of the constitution. How? A provision, article 338B, was added in the Indian constitution, through which the National Commission of Backward Classes got the constitutional status. Now, before the formation of National Commission for Backward Classes, the backward classes, identification. So, the backward classes were identified by the Kalekar Commission and the Mandal Commission of 1980. Kalekar Commission. So, please remember these two commissions, because question can be asked. Kalekar Commission is referred to which of the following? So, you should know that Kalekar Commission is referred to the OBC, other backward classes, right? Which means the Kalekar Commission and the Mandal Commission, it actually provided the groundwork for recognizing who are the socially and educationally backward groups at the national level. At the national level, who are the socially and educationally backward classes of people, so that their names can be included in the central list of other backward classes. So these two commissions are important. So make sure that these two commissions pertain to the OBC. Very important point for your, again, prelims examination. Now talking about the composition and appointment. Now talking about the composition. Now the commission is made up of chairperson, vice chairperson and 3 other members. So chairperson, vice chairperson and 3 members, and all these members are appointed by the President of India. Even their conditions and tenure. The conditions and tenure of the chairperson, vice chairperson and the 3 members is again decided by the President of India. So such terms, again, you may I find it very simple, but these all these things will be very confusing when you actually face a question, because there are so many constitutional, so many statutory, or so many executive bodies. So that's the reason I request you to make a list of all the constitutional, statutory, executive bodies, so that you know the concept, basic understanding is clear. Now, the powers of National Commission for the Backward Classes. Now, please remember that the National Commission for Backward Classes, it has the civil court part, which means that it can summon individuals. It can also make sure that they are present before them. It can request the documents and public records from courts or government offices, which means it is a quasi-judicial body. Why? Because it has the powers of a court. That's the reason it is referred to as quasi-judicial body. Again, questions can be asked in the form where the question can be, which of the following bodies are quasi-judicial bodies? So, quasi-judicial bodies are those bodies that perform the functions of a court, right? Then the functions. Now, what are the functions of NCBC? Now, it plays a very important role in ensuring the welfare of the backward classes. It investigates and monitors how the constitutional and the legal safeguards, for example, Constitution, we have Article 15, Article 16, then legal protection, so prevention of atrocities on the SC and ST Act for BCs are implemented, and submits an annual report to the President. Again, the NCBC, they prepare a report, and this report is submitted to the President of India. Now, additionally, the National Commission of Backward Classes, it also advises the government on the development strategies, and the policy, the planning, the welfare programs. Why? So that the members of the backward classes are socially and educationally uplifted. So it also advises. Again, the advice is, the recommendations are advisory. It's not binding on the government. So these are the functions of the National Commission of Backward Class. I hope the concept is clear. Now, once we understand the National Commission of Backward Classes, let us try to understand the National Commission for Scheduled Castes. Again, according to official data shared by the National Commission for Scheduled Castes, more than 47,000 complaints were received in the past 4 years, which means this context points to the discrimination faced by the scheduled castes. Yes, Surapu Reddy, any question? Hello, any question? Let me know if you have any question, any doubt, any confusion. Okay. Now, let us try to understand about the National Commission for the Scheduled Castes. So, we discuss about the National Commission of the other backward classes. Now, again, the National Commission for the Scheduled Caste is a constitutional body. Just like the National Commission for the backward classes, this one is a constitutional body. National Commission for Scheduled Castes was established through Article 338 of the Indian Constitution, and which means 89 Constitutional Amendment Act 2003 was passed in the Indian Parliament, and thus the National Commission for the Scheduled Castes, it got the constitutional status. Which means first the National Commission for the Scheduled Caste and the Scheduled Tribes were one body. And so a separate commission for the scheduled caste came into existence in the year 2004. With the law was passed in the year 2003, it came into force in the year 2004. And which ministry is responsible? Ministry of Social Justice and Empowerment is responsible for handling all the activities, policies, program planning related to the scheduled caste. Now talking about the service conditions, again the National Commission for the Scheduled Caste is made up of chairperson, vice chairperson and 3 other members, just like the National Commission for the Backward Classes. All the members, just like the NCBC, they are appointed by the President of India through a formal warrant. Again, the conditions and service are determined by the President. Now, please remember this point is important. The National Commission for Scheduled Castes, it also performs similar duties for the Anglo-Indian community. Anglo-Indian community. So this can be asked again in the examination. Which of the following bodies looks after the, let's say, welfare of the Anglo-Indian community? National Commission for Scheduled Castes, National Commission for Scheduled Tribes, National Commission for other backward classes, none of the above. The correct answer is National Commission for the Scheduled Castes. With respect to powers and duties of the National Commission for the Scheduled Caste, now again it has powers similar to that of civil court, which means again it's a quasi judicial body, which means again it can summon individuals, enforce their attendance, which means order them to appear before the National Commission for the Scheduled Caste, requisition public records to ask the public records from the government, demand the production of documents necessary for investigation, right? So these are the powers and duties of the National Commission for the Scheduled Caste. Now see the main responsibilities. The main responsibility of the National Commission for the Scheduled Caste, it includes investigating and monitoring how the constitutional and the legal safeguards, right? How the constitutional and the legal safeguards for the scheduled caste are followed. How they are being followed. And then they also need to prepare a report. This report is submitted to the President. Now, the SC and ST Prevention Act Report 2022. This report shows that 13 states were responsible for 98% of all the registered cases under that. Which means of all the cases registered in our country, 98% cases were registered in these 13 states. And if you look at the contribution of each and every state, so Uttar Pradesh, Rajasthan, Madhya Pradesh, Bihar, Odisha, so again just try to remember the top 2 or 3 states, which means of all the cases, right, the highest number of cases were filed in the state of Uttar Pradesh, right? So these 13 states, it contributed to the 98%, almost 98% of cases filed in our country, and Uttar Pradesh being the highest. Now this National Commission for the Scheduled Caste, the constitutional provisions. So we know Article 5, Schedule 5 of the Indian Constitution deals with the administration of scheduled areas and scheduled tribes, right? Then this is the constitutional provision, this is the legal provision. Article 15. Article 15 talks about reservation in education. Article 16, public employment. Article 17, abolishes untouchability. Article 46, DPSP, Directive Principles of State Policy, directs the state to promote the educational and economic interests of weaker sections, especially the SCs and STs. Then 243, reservation in every panchayat. 73rd Constitutional Amendment Act. 243T, Panchayat. 74th Constitutional Amendment Act. Panchayat is 73rd Constitutional Amendment Act. Municipality, 74th Constitutional Amendment Act. 335 requires that the interests of SCs and STs be considered in public employment, while maintaining administrative efficiency. So reservations has to be given keeping in mind the administrative efficiency. Article 330, reservation of seats in the Lok Sabha, House of the People. 332, seat reservation in the State Legislative Assembly. So these are the constitutional and legal. So please remember, you do not have to mug it up, but just going through it will help you understand or remember the key constitutional and legal safeguards. Right? I hope this topic is clear to you. Now let us discuss the next topic. The next topic is about the examination that you all are preparing. UPSC. UPSC is the body that conducts examination for the civil services examination for which you all are preparing. So again, the name is not important. Who has been appointed is not important. Important is to understand the constitutional provision of the UPSC. Now, first one is the constitutional status, which means UPSC again is a constitutional body. What is the responsibility? The responsibility of UPSC is to recruit officers, select officers for the Central Civil Services and the All India Services. All India Services comprises of IS, IPS and Indian Forest Service. The UPSC, it is governed by Article 315 to 323 of the Indian Constitution under Part 14 of the Constitution. So this is the constitutional provision of UPSC. The appointment and composition. Now, the members of the UPSC, it includes the chairperson appointed by the President of India under Article 316A. So who appoints? It is the President. Now please remember, this is a very important point for your examination. The Constitution does not prescribe specific qualification. No specific qualification is prescribed for appointment. So again, the question can be, the Constitution prescribes specific requirements, specific qualification. No, with respect to UPSC, it does not prescribe specific qualification. But it mentions that at least 50% of the members, at least 50% of the members must be or must have a minimum of 10 years of experience in the government of India or state government. So experience of 10 years in the central or the state government is important. Again, the total number of members is not fixed. Yes, it includes a chairperson appointed by the president, but the total number of members is again not fixed, which means the total number of members in the UPSC is again decided by the president, which means president will decide as per the aid and advice of the Council of Ministers, acts as per the aid and advice of the Council of Ministers. So qualification is not prescribed by the UPSC. Total number of members is not prescribed. Usually the commission, it consists of 9 to 11 members, including the chairperson. No fixed number is prescribed by the Constitution. Now the tenure and service conditions. The tenure of UPSC members, chairperson or let's say the members, is 6 years or until the age of 65, whichever is earlier. And again, the service conditions is determined by the President of India. And once appointed, once the members are appointed, these conditions cannot be changed. And once the chairperson leaves the office, he is not eligible for any future appointment in the central or the state government. Once he leaves his office, he is not eligible. for any further appointment. Members cannot be reappointed but may be appointed as a chairperson of UPSC or the State Public Service Commission. So the members, again, they cannot be reappointed but they can be appointed as the chairperson. They cannot work in any other capacity except the chairperson of the UPSC or the State Public Service Commission. And in case a member is appointed as a chairperson of UPSC or State Public Service Commission, the total tenure still cannot exceed 6 years or until the age of 65, whichever is earlier. So this point is very, very important to remember for the prelims examination. Such points are asked usually in the examination. Talking of the salaries and pension, the salary and pension again is of the chairperson and members are charged on the Consolidated Fund of India. Now, their salaries and pensions being charged on the CFI, it ensures their financial independence and security of tenure. The functions and consultation. Now, Article 320. Article 320 of the Indian Constitution mandates that the UPSC must be consulted. Who consults? The central government consults the UPSC in matters relating to the recruitment of civil services and posts. So, it is the central government who consults the UPSC, that is the chairperson and members. However, here you need to remember that the Supreme Court has clarified that this consultation is again advisory. It is not binding. This is what the Supreme Court has clarified. And that's the reason, even if the UPSC is not consulted, it does not give rise to any legal or let's say any legal issue in the court. The removal and resignation. Now, talking of the removal and resignation, members can be removed by the president. And that doesn't mean that the president can remove a member as per his whims and fancies. No, there's a procedure laid down in the constitution. So there's a procedure laid down. It cannot be arbitrary. There's a procedure laid down in the constitution. As per the procedure, a member is removed. But if a member wishes to resign, the member has to submit the resignation to the President of India. Now, this one is important. Other roles and responsibilities. Now, the UPSC may also assist the state governments in conducting joint recruitment examination if such a request is made by the governor of a state and approved by the president. Which means the governor on behalf of a state has to request the president, and once the president approves, the UPSC can help the state government in conducting the recruitment or in conducting the examination to recruit the officers at the state level. And again, here you need to remember that the commission submits an annual report to whom? To the president. Then the president will ensure that this report that is submitted by the UPSC is led before the parliament. Why? To ensure transparency and accountability. So in this context, we'll also understand about the State Public Service Commission. Now, this State Public Service Commission is governed by Articles 315 to 323. It's the same like UPSC, no major changes. The chairperson members, they are appointed by the president, UPSC, here by the governor of the state. The number of members is not fixed. Again, it's a similar provision. Tenure is 6 years or 60. It was 65 for UPSC, 62 for the State Public Service Commission. Although appointed by governor, they can be removed only by the president. UPSC removed by the president, but again, the Joint State Public Service Commission, now it's a statutory body. right? It's a statutory body, not a constitutional one. It is created by parliament if requested by the state legislature, right? The chairperson members are appointed by the president. Though the Joint Public Service Commission, right? The purpose of Joint Public Service Commission is to recruit these officers, recruit the candidates at the state level, but the members are again appointed here, not like the governor, appointed by the president, and then it handles recruitment jointly for multiple states, again upon the request of the state legislature. So UPSC, State Public Service Commission, and the Joint State Public Service Commission. I hope each and every point is clear to you. Ram Kumar, any question, any doubt? Please let me know if you have any question, any doubt. Now, let us understand, discuss the Central Vigilance Commission. Now, the Central Vigilance Commission's 2023 report revealed that highest number of corruption complaints were made against railway employees, followed by those working in Delhi's local bodies and public sector banks, bringing attention to key sectors under the vigilance scrutiny. So, this is a report of the Central Vigilance Commission. Let us try to understand about the Central Vigilance Commission. Central Vigilance Commission or CVC is an independent body that does not function under any ministry or department. Very, very important point for your prelims examination, which means it is directly accountable to the parliament of a country. The central government consults the CVC while framing rules or procedures related to vigilance and disciplinary issues. Just like the central government consults the UPSC for the civil services, the posts, here the central government it consults the CVC while they are framing rules or procedures relating to vigilance and disciplinary issues. The powers and functions of the CVC. Now, the CVC was originally set up under the CVC ordinance, which means it came through an ordinance route. It exercises superintendence watch over the CBI. CBI was established through the Delhi Special Police Establishment. This is what we discussed yesterday. If matters of corruption under the prevention of corruption. So, whenever the CBI is looking after the corruption case, corruption complaint, the CVC has superintendence control over the CBI, which means the CVC can request a report from the CBI. So this point is very important. It can conduct inquiries and investigations on references made by the central government. So upon references made by the central government, CVC can look into inquiries and investigation. In cases involving the central government employees, the officials in corporations, the public sector undertakings, then the local authorities under the center's control, any public servant covered under the Prevention of Corruption Act. So, upon reference made by the central government, CVC can look into enquiries. CVC has the power to approve investigation involving senior officials under Section 6A of the Delhi Special Police Establishment Act. Has the power to approve investigation. They have the power to approve the investigation, post which the investigation will begin. See, when it comes to powers and functions, the advisory, the jurisdiction, you do not have to, cram the facts. You just have to read it once, twice. That will be more than sufficient to remember the points. Now, when it comes to polity, the constitutional, the executive bodies, or let's say statutory bodies, it is best to always compare the constitutional bodies with statutory and executive bodies. So when you compare all these bodies, it will be easy for you to remember the difference between these bodies, so that if a question is asked in the examination, you will be in a position to attempt the answer correct. That's the reason always. This is the best way. This is what I'm suggesting you. Again, doesn't mean that you have to follow this method, but when it comes to the bodies, it is best, or it is recommended, to always compare the bodies for better understanding and better clarity. Else, it might lead to a lot of confusion. Again, the final call, it rests upon you. Now, advisory role. The CVC, it serves only as an advisory body to the Government of India. Just advisory body to the Government of India and departments in corruption related. So, this is very, very important. It also monitors the vigilance administration across the central government ministries, PSUs and control bodies. Jurisdiction, it extends to Group A officers of the central government and officials in corporation, PSUs, local bodies as notified by the government. Judicial powers, again powers similar to that of civil court, which means again it is a quasi judicial body. So these are the powers. Again, please read by your own. There is nothing much to explain. Composition and service, again the CVC consists of the Chief Vigilance Commission and 2 Vigilance Commissioners. They are appointed by the President on the recommendation of a committee. Now this point is very, very important. Committee comprises of the Prime Minister, Home Minister, Leader of Opposition. The tenure is 4 years or until the age of 65. That's the reason I suggested you to compare. At times it's 4 years, 6 years, 65, 62. A lot of confusion. That's the reason it's better to compare all these bodies. They are not eligible for reappointment. Salary and allowances, again, they are equivalent to those of the chairman of UPSC. Removal, they are removed by the president for reasons such as being adjudged, insolvent, engaging in moral turpitude. So again, this is something self-explanatory. So I request you to please read by your own, right? The next topic pertains to PIB fact check unit. The central government has officially designated the fact checking unit operating under the Press Information Bureau, because there's a lot of fake news, right, on the social media. It does the rounds, and once the fake media is spread, it is consumed by so many people. That's the reason the central government has officially designated the fact checking unit operating under the Press Information Bureau of the Ministry of Information and Broadcasting as the official fact checking authority for the government related information. Well, first let us try to understand about the fact check unit. Under this fact check unit is under the Press Information Bureau. This unit has been set up under the Information Technology Rules of 2021. Main goal is to act as a deterrent against fake news, to prevent fake news and misinformation, particularly concerning government policies, schemes and official announcements. The functions either on its own initiative, that is suo motu, or based on public complaints or references received. It works to detect any fake news, counter and correct any misinformation spreading about the government. To carry out its work, the FCU relies on modern tools and technologies, including reverse image research, video analysis, other verification methods. So this is about the fact check unit. So the features is something that you need to remember for the prelims examination. Now the fact check unit, it classifies information to 3 categories. One, fake. If the content is completely fake and has the potential to deceive or manipulate the audience, even without malicious intent, it is labeled as fake news. Then second, misleading. If a piece of content uses selective facts or distorted figures and can mislead or deceive the audience, it is marked as misleading. There's a difference between fake and misleading. True, any content that upon verification is found to be factually correct is marked as true. So fake, misleading and three, these are the categories that has been classified by the fact check unit. So again, these categories can be asked in the examination. So classification categories, so these three categories, remember it. Accessibility, the fact checking unit ensures that its fact checking efforts are accessible to people with disabilities as well. Again, an important point for your prelims. This includes providing alternative text for images shared on social media so that people using screen readers or assistive technologies can also access the verified information. So this is the fact checking unit. So at times students, it may seem that the topic is not important, but questions can be asked about any topic. That's the reason our duty is to be prepared with each and every topic that has appeared in the last 12 to 15 months, right? Now again we discuss about the law commission. We already have discussed about the law commission, right? So again this law commission is talking on the 23rd law commission, which will be in effect from 24 to 2027. So you should know that 23rd law commission has been established. So again about the law commission of India, we already have discussed. Now the law commission is a executive body. It is ad hoc advisory body who forms it, the government of India, which means through an executive order. And it works under which ministry? Ministry of Law and Justice. What is the purpose? It plays a, or the purpose is to give legal reforms, suggest reforms so as to make changes in the India's legal framework. And again, the advice recommendation is not mandatory, it is not binding, it is just advisory. Historical background, again this point is important. I think we did not discuss this point. 4 law commissions were established in British India. The first one was formed in 1834 under the Charter Act. After independence, the first law commission was set up in 1955. The 22nd law commission was constituted in the year 2020 for a 3-year term until 24. Now this is the 23rd law commission. So this one is 1, 2 before independence, 1 after independence, 3. So 4 law commissions. So this point can be important for your prelims examination. So again about the 23rd law commission we already have discussed, so I am not going to waste time in again repeating the same point. Today itself we have discussed about the 23rd law commission and the terms of reference given to the law commission, 23rd law commission. And this topic marks the end of the topics under the theme constitutional, statutory and executive bodies, right? So students, now let us start with a new theme, right? And the new theme is elections. I'll be back in a minute. Okay, students, welcome back. So, as discussed, we'll be starting with a new theme, and the new theme is election. So, we'll be discussing the topics under the theme elections. We'll be discussing topics like the comparison of US and the Indian electoral system, then the election commission, releasing new rules for the registered political parties, and then delimitation, what is mixed member proportional system. This was in news, so I feel that this may be asked in the examination. The home ballot system, electoral bonds, model code of conduct, one nation one election, allocation of symbols of to political parties, nota in Indian elections, and twin candidature in elections. So these are the 11 topics that we shall be discussing under the theme elections. Let us start with the first topic. The context being Donald Trump, he has won the 2024 US presidential election. So let us try to compare the presidential system in US and India, because questions, I think the question in the year 2021, a question was asked on the French presidential election. So let us try to compare. First, the system of government. It is federal republic presidential system in India. So India follows parliamentary system, US follows presidential system. Both the countries have federal system of governance where the power is shared between the central government and the local units. Head of the state, who is the head of the state? Both president as well as president. But in India, president is the ceremonial head, his head only for the namesake. The real power rests with the Council of Ministers headed by the Prime Minister. But here in the United States, President, he is the most powerful authority. Head of the government, President, and head of the government in India is the Prime Minister. And the legislative structure, again both India as well as US, they have bicameral structure, which means two houses. In India, we know Parliament. Parliament comprises of Lok Sabha and the Rajya Sabha. Rajya Sabha is referred to as Council of States, Lok Sabha, House of People. In America, Parliament is referred to as Congress. Congress. Lok Sabha, like Lok Sabha in America, Americans have House of Representatives. Like Rajya Sabha in India, the USA has Senate. Now, the House of People has maximum 550 members, right? Council of States, Rajya Sabha has 250 members. House of Representatives has 435 elected representatives. Senate has 100 members. Which means from every state, there are 50 states in America. Every state sends 2 members to the Congress Senate. So every state sending 2 members, which means 15 to 2 is 100. So there are 100 members in Senate. So yeah, Senate and House of People, House of Representatives. In India, House of People and the Council of States. Judiciary again is independent. In both the countries, it is independent. Supreme Court is the highest authority. Federal structure, it is strong federal system. But here's a small difference that you need to understand. In America, states have significant autonomy. But in India, though India is referred to as federal country, but it's slightly inclined towards the center. The powers are slightly inclined towards the center, which means it's a quasi-federal state. India is a quasi-federal state. The powers are more inclined towards the center. US, the states have significant autonomy. The state government, the governors and legislatures with significant powers, states have independent constitutions. Here the governors are appointed by the central government. So governor is a feature of the unitary system, not federal system. So here the governors are appointed by the central government, and the states share a common constitution with the union, but in America the states have a constitution of their own. Political parties, predominantly there are two political parties. In India we have multi-political parties. We have national political parties like BJP, Congress, and then we have state political parties like Shiv Sena. So this is the difference. But the most important thing that we need to understand is how a president in India and president in the United States are elected. So this is what we need to understand. So I request you to please focus on this part. How the president in India and how the president in the America are elected. Let us start with India. Let us start with India. Now, in India, the president is chosen through indirect election, which means people do not elect the president. And the president of India, though he is chosen in an indirect manner, the way the system has been designed is to reflect both the national as well as the regional representation. How I'll tell you why? Because both the members of the Lok Sabha and the state members are, or they constitute a part of the electoral college who elect the president of India. So it reflects both the national as well as the regional interest as well. And this method of indirect election, it ensures that the voices of states and the union territories are also included with the parliament. And the election for the president of India, it uses a system of proportional representation by single transferable vote. This is a system followed for the president, for electing the president of India. Proportional representation by single transferable vote. This is a method that allows voters to rank candidates in order of preference, which means a voter can vote more than one candidate. He votes as per the order of preference. In the general elections, the voter can only vote one candidate. But here, for the election to the president, the voter can vote more than one candidate. And then to contest the election, right, the eligibility criteria is that the candidate must be an Indian citizen, at least 35 years old, and eligible to become a member of the Lok Sabha. So this is the eligibility required for a candidate to contest the presidential election. And also they must not hold any office of profit. They must not hold any office of profit under the central or the state government. Now talking about the electoral college. What do you mean by electoral college? The members who constitute or who are part or who vote in the presidential elections. This electoral college is responsible for electing the president and consists of the elected members of both the houses. Elected members of Lok Sabha plus Rajya Sabha. Elected members of Lok Sabha and Rajya Sabha, and also elected members of the state legislative assemblies. Elected members of all the state legislative assemblies, not only state but also union territory, which means Delhi and Puducherry. Why? Because Delhi and Puducherry have elected MLAs. So Delhi and Puducherry are the only union territories having uh, elected MLAs. Now we also have Jammu and Kashmir. Jammu and Kashmir having elected members of legislative assemblies. So who all participates? One, elected members of Lok Sabha and Rajya Sabha, elected members of state legislative assembly and union territory having legislative assembly. I hope this point is very important, because this question has been asked in the examination. Now during the voting process, the voting is conducted by, again, secret ballot. The voting is conducted by through secret ballot, and as I told you, the voters, they rank candidates based on their preference. Now, please remember, again, this is a point can be asked in the examination. The value of votes is not the same for all the members of parliament. The value of votes is not the same for all, which means the members of parliament have votes of equal value. Each member of parliament has vote of equal value, but the members of legislative assemblies have different vote values. The vote of one MLA in a state is the same. The the value of vote of an MLA is the same as for the other members as well. So let's say Maharashtra. The value of vote of one MLA is the same as that of other members, but the value of vote of an MLA in Maharashtra and that of Uttar Pradesh is different, and this depends on the population of that state. So let's say if the population is more, the value of vote of a member belonging to that state is more. So it depends on the population. And then the candidate who secures the highest value of votes win the election. And if no candidate secures the required quota, it's not that 50% no. It's not that any candidate who is receiving majority votes wins the election. No. If the candidate has to, secure a required quota to win the election. And if no candidate it secures required quota in the first round, then the votes are transferred to the next preference. This is what we understand by the term single transferable vote. And then the counting continues in a preferential voting manner. The entire election process must be completed within 6 months before the term of the sitting president ends. So before the expiry of the term of the president, within 6 months, the election process must be completed. So this is the presidential election process in India. I hope this point is clear. Now, let us discuss the presidential election process in the United States. Now, in the United States, right, in the US, the voters don't vote directly for the president, just like India. Instead, they vote for a group of people called the electors. And these electors are the ones who actually vote to choose the president, which means the people of America, they vote electors. These electors then vote the president. Now, these electors are part of a group called Electoral College. Just like in our country, Electoral College comprises of the elected members of both the houses and the state legislative assemblies. In America, uh, the electors whom the common people vote are part of the Electoral College. And there are in total 538 electors, which means 538 electors are elected by the common people. Each state in America is allotted a number of electors based on its representation in the Congress. That is, the number of its senators and House members. To win the presidency, a candidate must secure a majority of 270 electoral votes. Which means each state gets a certain number of electors. Each state is allotted a certain number of electors, right, based on how many people live in that state, depending on the population. So let's say bigger states like California, they get more electors, while smaller states like Vermont, they get fewer. Again, it depends on the population. Now, to become the president, a candidate must get at least 270 of the 538 electoral votes. But before the actual election happen, each political party in the country decides who their candidates will be. That is, the electors will be. Now, this decision is made through a series of state level voting events and internal party decision, where people and party members vote to show support for different possible candidates. The person who gets the most support becomes the official candidate of that political party. Then in the main election, which is held in the month of November, people across the country vote for the electors. But when they vote for a presidential candidate, they are actually choosing a group of electors who have promised to vote for that candidate, the presidential candidate. And then finally, in the month of December, the electors meet in their own state capitals and cast their official votes for the president and also the vice president, which means the common people are voting the electors, electing the electors are electing the president and vice president. The votes are then sent to the Congress where they are counted in the month of January. And the presidential candidate who gets 270 or let's say more votes becomes the president of the United States of America. And if no one gets 270 votes, then the decision goes to the House of Representatives, where each state gets one vote and they choose the president from the top candidates. The Senate will then vote to decide who will be the vice president. The person who wins officially becomes the president of America, right? Which is when they take the oath and begin their term. And this is how the president in America is elected. Any question, any confusion, I request you to please ask. I hope you understood the difference in how a president is elected in India and America. Again, in both the countries, an indirect election system is followed. So we elect the MLAs and MPs. The MPs and MLAs they elect the president. The value of vote of MP and MLA is not the same. The value of vote of one MLA belonging to a state and belonging to other state is again not the same. So such statements can be asked in the examination. In America, the common people they vote, they elect the electors, the 538 electors, they vote for the presidential candidate. Again, indirect system is followed. The next topic, the Election Commission of India has recently revised the rules for the allocation of election symbols to the registered but unrecognized political parties. Registered but unrecognized political parties. So what exactly? So who are the registered unrecognized political parties? Something that you need to understand because questions can be asked on this particular concept. So the registered but unrecognized political parties, they are the political parties that are either newly registered or have not received enough votes in elections to be recognized as a state party. Registered recently or did not get enough votes to be considered as a state political party. Now, some of these parties may also never have considered elections or contested elections after registration. So they are registered but they have not contested elections, which means though these political parties are not recognized, these parties are eligible to receive a common election symbol, subject to they commit to fielding at least 5%, at least, yes, it is at least 5% of the total candidates in the upcoming assembly election in a state. They are referred to as registered but unrecognized political parties. Registered recently but did not contest or did not receive enough votes to be considered as a state political party. Still, they are given common election symbol when they commit that okay, we'll contest 5% of the total candidates in the upcoming election. So this is what we understand by the term registered unrecognized political parties. So this can be asked in the examination as it was in the news. So I request you to please remember what exactly one understands by registered unrecognized political parties. And then the updated symbol allocation guidelines. Now these guidelines, again, that I mean there are less chances of the guidelines being asked in the examination, but there is no harm in just going through the guidelines. So as per the existing 2014 guidelines, the registered unrecognized political parties wishing to obtain a common symbol were required to submit documents such as these. However, the revised rules under the 2024 rules must now submit additional mandatory documents. Which documents? Audited financial accounts for the past 3 financial year, expenditure statement for the last 2 elections contested, a signed application form with the signature of an authorized office bearer. So these are the documents that the registered unrecognized political parties need to submit. Now, what is the registration process under the RPA 1951? So this can be asked. Political parties seeking registration must apply to the Election Commission within 30 days of their formation. Once they form, within 30 days they have to. The EC derives this authority to oversee party registration from Article 324 of the Constitution and Section 29 of the RPA Act. Section 29A outlines essential conditions for registration. For example, Indian citizenship of party members, the purpose of contesting elections, a minimum of 100 registered electors as founding members of the party. Interestingly, while the law provides for registration, there is no formal mechanism to again, this can be asked in the examination. So there is no formal mechanism to deregister a political party, which often results in their continued legal existence. And what are the benefits of registering a political party? What are the benefits? So once a political party registers, what are the benefits? One is a symbol preference, which means the registered political party candidates, they get priority in receiving free election symbols, and this actually election symbols help improve their visibility on the ballot box. The second is party recognition, which means the registered political parties can be granted state or national political parties status if they fulfill certain criteria as laid out by the Election Commission of India. So these are the benefits for the political parties once they registered as a political party before the Election Commission of India. I hope you understood the topic. So I guess we have discussed 2 to 3 topics under the new theme elections, right? So we'll end the lecture here. The remaining topics we shall discuss in the next class. But students, make sure you're downloading the notes of the topics that we're discussing from the description box. Make sure that you're spreading the word, spreading the video, informing other aspirants to please refer to our channel, refer them to our channel, and make sure they also get the benefit of the Prelims Masterclass program that we have launched exclusively for the students appearing in this examination. Make sure that you revise, make sure you continuously revise and also jot down the important points so as to ensure that you remember all the points that we discussed in the examination. Okay, so make sure you're hitting the like button, subscribing the channel, and again forwarding the video to as many people as possible. On this note, I'll call it a wrap. Thank you so much for watching.